If your parents pass away without a will, one sibling does not inherit the entire estate. So what's going to happen is when your parents pass away without a will, the assets will get distributed per the intestate laws of your state. So as an example, in Georgia, your assets get split evenly between your spouse and your kids, with your spouse getting a minimum of 1/3. If you pass away without a spouse, but you do have kids, the kids will split those assets evenly. This is true even if your parents have told one of the kids that they get to inherit everything, unless there is a legal document that is signed and notarized that outlines the distribution of those assets correctly and legally. Then they will get split per the intestate laws of that state. No matter what was said before or verbally agreed upon, that's just how it's going to be. And so your parents have a couple options on how they can distribute the assets out to the kids or the spouse. So they can set up joint tenants with rights of survivorship on property if they want to co-own that property with another individual like their spouse. Then when one of them passes away, that property will go to the other individual and avoid the probate process. If you have kids that you want to avoid the probate process with, you can set up designated beneficiaries or transfer on death deeds where it is available. That way your parents would have full ownership while they're alive, and the assets will go directly down to the designated beneficiaries when they pass away. Or you could put all the assets inside of a revocable trust that will allow all those assets to avoid the probate process. You can keep those assets inside the revocable trust to take care of the surviving spouse throughout the rest of their life. And then when the surviving spouse passes away, all those assets can be distributed out to the surviving kids, however it is outlined inside of that trust document.